Now, with potentially a liberal majority, which is likely, I would think, to try to revisit some of the decisions in the past, say that have to do with maybe Act 10 or voter ID, or is it okay to carry guns on city buses, things like that the court has ruled on. Now, I would be willing to bet that it will be the conservatives who argue stare decisis. No, we've already decided this. You can't go there.
We should be
right?
listening for.
And if I could just add something to that, so even within the bounds of stare decisis, previous cases can be distinguished. Just because the court has previously said something doesn't necessarily mean that that's going to be binding precedent going ahead. And in terms of the least change standard, this is an argument that the plaintiffs have confronted, where they've basically said, acknowledging that this was the approach that the Supreme Court had applied before, but this is just a very different circumstance for some of the reasons that I explained before, where the posture of this case is different. The claims themselves, they allege that the districts are unconstitutional. So it wouldn't make sense if the districts are unconstitutional to follow a least change approach, saying that we're going to stick as close to these unconstitutional districts.
It was flawed from the beginning.
Exactly, as we can. And there are also kind of other critiques that they had of the least change approach. So it's not necessarily overruling precedent. It could be a distinguishing precedent.